Case 69, U.S. v. Smith. We find ourselves at the U.S. Court of Appeals for the Eighth Circuit. Facts. In the early morning hours of July 11, 2012, authorities in Omaha, Nebraska learned the cockpit of an inbound Boeing 737 had been illuminated by a laser. The local police department dispatched a helicopter to locate the laser. As the police helicopter approached the approximate location of the laser's source, Smith, standing in his backyard, directed his laser pointer's green beam at the helicopter, illuminating its cockpit. Smith's beam struck the helicopter several times, but when the helicopter got close, his beam disappeared. Unable to pinpoint Smith's location, the helicopter was forced to depart, but as the helicopter began to do so, Smith again shone his laser's beam on the helicopter. The helicopter resumed its approach until again the beam disappeared. In what the helicopter pilots described as a back-and-forth game of cat and mouse, the helicopter approached Smith when the laser was visible and feigned departure when it was not. Ultimately, the pilots were able to identify Smith's exact location and dispatched a ground officer. The ground officer found Smith standing in his backyard, pointing a green laser pointer skyward in the direction of the helicopter. The officer handcuffed Smith and removed him for questioning. According to the arresting officer's testimony, Smith stated that earlier he had been shining the laser at aircraft that he thought were far enough away that it wouldn't actually reach those aircraft. Smith denied actually shining the laser at the police helicopter. A grand jury indicted Smith of knowingly aiming a laser pointer's beam at the police helicopter in violation of 18 U.S. Code 39A. The day before trial, Smith submitted proposed jury instructions, including a theory of defense instruction, proposing he could not have knowingly aimed the beam at the aircraft if he mistakenly believed that the laser beam would not travel the distance necessary to reach the aircraft. The jury found Smith guilty of violating this law. Smith now appeals his conviction. Issue: whether Smith violated 18 U.S. Code 39A. Holding: the court affirmed because the district court correctly interpreted 18 U.S. Code 39A. It did not err in excluding Dr. Sidebottom's irrelevant testimony and rejecting Smith's inapposite proposed instructions. Let's look at why. The case required the court to interpret 18 U.S. Code 39A for the first time. This subsection imposes criminal liability on anyone who knowingly aims the beam of a laser pointer at an aircraft in the special aircraft jurisdiction of the U.S. or at the flight path of such an aircraft. Smith's appeal targeted the district court's exclusion of Dr. Sidebottom's testimony and rejection of Smith's proposed jury instructions. As both parties agreed, the foundation of these challenges and the crux of the appeal was the definition of the phrase knowingly aim. Section 39A covers an offender who knowingly aims the beam of a laser pointer at an aircraft, or at the flight path of such an aircraft. Smith argued this language requires a defendant to knowingly point a laser beam, intending the beam to strike the targeted object, whereas the government defends the district court's understanding by arguing an offender need only direct the beam toward the target. The court reviewed de novo this question of statutory interpretation. Smith argued that the district court only applied knowingly to the aircraft element of 39A and did not apply knowingly to the aim the beam of a laser pointer at element. This argument missed its mark. According to the court, the district court never suggested knowingly modifies only the aircraft element, but instead recognized there was no question the mens rea requirement modified the aircraft element and then moved on to explain the real task at hand was determining how knowingly modifies aims and, more importantly, what Congress meant by the word aim. Thus, contrary to Smith's contention, the district court correctly recognized knowingly modifies both the aim and the aircraft elements. Nor did the district court's interpretation of to aim at, that is to point at, wash away the knowingly requirement. Under the district court's interpretation, knowingly still modifies aim to require that an offender understand he or she is pointing or directing the laser's beam at an aircraft, regardless of whether the offender intends to strike the aircraft. There was thus no real disagreement as to whether knowingly modifies aim. Smith's real argument, as the district court observed, came down to the proper construction of the word aim. Smith contended the statute's use of aim unambiguously carries with it an intent to hit the object targeted. This word's common American usage necessitates no such intent requirements, the court noted. The district court looked at Webster's Third New International Dictionary 45, which defines the verb to aim as to point in a particular direction or at a particular object. Thus, wrote the Court of Appeals, aiming may accompany an intent to strike the target, but the word's common meaning is not limited to such instances. Ordinary use of the word aim confirms this understanding. The court gave an example. Consider the familiar phrase, "ready, aim, fire." A ceremonial commander at a military memorial orders the riflemen to ready their rifles, aim the barrels, and then pull the triggers. The riflemen dutifully obey the second of these three orders not by manifesting any present intent for either barrel or bullet to strike any target, but instead by directing the rifle's gaze. By using the term aim at rather than some results or contact-oriented term, for instance knowingly illuminating an aircraft, Congress specified the act of directing the active laser pointer's beam, not of manifesting one's intent to strike the target. Relying on plain text and common usage, the Eighth Circuit concluded 39A's requirement that the laser beam be knowingly aimed does not require an offender to intend the beam to strike the aircraft or flight path in question. The rule of lenity requires a criminal statute be construed in a defendant's favor, where after considering text, structure, history, and purpose, there remains a grievous ambiguity or uncertainty in the statute, such that the court must simply guess as to what Congress intended. Smith did not invoke this rule, instead contending the statute is unambiguous in his favor. As the court had explained, however, 39A's common and ordinary meaning gave Smith fair warning his conduct violated the law. Because the district court correctly interpreted 18 U.S. Code 39A, it did not err in excluding Dr. Sidebottom's irrelevant testimony and rejecting Smith's inapposite proposed instructions. The Eighth Circuit thus affirmed the decision.